Hello, this is Matt on the Moon Lambeau channel, and some major news just broke as I was, by coincidence, just recording my very last video. I published it; it's live now, and then I go to Twitter, and Ripple CEO Brad Garlinghouse has highlighted that a judge has ruled that XRP today has not been declared a security, which directly affects a lot of stuff, including a lawsuit that Tetragon had filed against Ripple, with Tetragon being a shareholder who led their Series C funding round a little over a year ago. And so there's no question that today, and I know the Bitcoin maxi trolls like to say, no, the SEC said that XRP today is a security, so it is. No. And I've been saying forever, they're claiming that it is. There is no legal declaration that XRP is a security, and now we have clarity on that from a judge. So I'm going to share with you comments from Ripple CEO Brad Garlinghouse, which just dropped in less than an hour. As I'm recording this, what time is it? It's 10:05 p.m. Central Standard Time. I'm in the Midwest in the United States here, and less than an hour ago, Ripple CEO Brad Garlinghouse put a few tweets out, along with Stuart Alderodi, who is like a legal general counsel. I forget if that's his exact title or something kind of like that, but I'm going to share with you all the specifics here. Now, I do want to be clear that I don't have a legal background of any kind, so I'm not offering legal advice. I also don't have a financial background. I am not offering financial advice, and so you should not buy or sell anything because of anything that I say or write. I'm just an enthusiast that likes making YouTube videos about crypto and XRP and Ripple and all that jazz. That is indeed all that it is. But I very much appreciate all the support, so thank you for stopping by. Now, just to quickly set the table before we jump into the very latest news, and I promise I'll be brief, but I want to make sure everybody has a full perspective on this, or else the latest news isn't going to be nearly as meaningful. Here's a story. This is actually Ripple's blog series, which they call Ripple Insights. And this is from December 20th, 2019, so a little over a year ago. And this was big news, by the way. The headline of this blog, Ripple caps record year with $200 million Series C funding. Today, Ripple is thrilled to announce $200 million in Series C funding, an investment that marks a record year for the business and further proves the value of blockchain technology in improving global payments and the broader utility of the digital asset XRP and the XRP ledger. The Series C was led by Tetragon, with participation from SBI Holdings and Route 66 Ventures. These notable investors not only underscore Ripple's long-term potential, but as partners, they offer invaluable industry insight and expertise to help Ripple's business grow on a global scale. And so this was significant for a couple reasons. Typically, when a company goes through Series C funding, it means one of two things. Either they're getting ready to sell to another entity, and it can bump up their valuation so you can get a bigger sale price, or they're preparing to go public. And we know, based on comments from Ripple CEO Brad Garlinghouse, and I guess it was January of 2020, I'm pretty sure, he said that, in terms of Ripple going public, he said, and I'm paraphrasing, but it's not that far off from being verbatim. He said that we won't be the first, but we won't be the last in terms of a blockchain company going public. So based on that, we know that there are plans for Ripple to do that. Obviously, what happened with the pandemic last year, and then what happened with the SEC coming after Ripple claiming that they were selling XRP as an unregistered security, that's kind of hampered things. So they kind of shelved that undoubtedly, but once this is all cleared up, I still think it'll ultimately occur. It's just a matter of time. And so what happened after that? So after the SEC came after Ripple, which occurred on December 22nd, 2020, all sorts of S-word hit the fan. Coinbase and all sorts of other United States-based cryptocurrency exchanges halted trading of XRP. And then this news dropped January 5th, 2021. Here's the headline from CoinDesk. Tetragon sues Ripple to force stock redemption. One of Ripple Labs' big financial backers is looking to reverse its bet on the XRP issuer. Tetragon Financial Group Ltd., the multi-billion-dollar asset manager turned plaintiff, had led Ripple's $200 million funding round in December 2019. On Monday night, the UK-based firm moved to exit its position in a sealed filing in Delaware Chancery Court, according to Bloomberg. And so their claim was basically that there was a clause, and I'm going to read you Ripple's statement too, but basically there was some sort of clause in whatever the final agreement was between the two companies that if XRP were to be declared legally a security, that Tetragon, they can basically bow out, they're out of the picture, and then Ripple would basically owe them their investment back, right? More or less. They're, just it's a little oversimplified, but I think for the purposes of this video and just understanding functionally what's going on, I think it's sufficient. And so that very same day, January 5th, 2021, Ripple put out this very brief statement titled Our Statement on Tetragon Filing. In Ripple's Series C investment agreement, there is a provision that if XRP is deemed to be a security on a go-forward basis, then Tetragon has the option of having Ripple redeem their Ripple equity. Since there has been no such determination, this lawsuit has no merit. We are disappointed that Tetragon is seeking to unfairly take advantage of the lack of regulatory clarity here in the United States. The courts will provide this clarity, and we are very confident in our position. And so I covered this when it happened, and my position at the time was, look, if these are the facts, if that was the nature of their agreement, then Tetragon's in the wrong. If it is as Ripple described, Tetragon is in the wrong, because I've been stating the whole time that although the SEC is stating that today XRP is a security, that's not some sort of legally binding sentiment that makes it so. It just isn't. And we got that clarity today. So take a look at this. Now it's been 53 minutes since this dropped from Stuart Alderodi. Here we go. General counsel at Ripple, over 30 years of legal experience with expertise in banking, regulatory affairs, and complex litigation. And check out what he wrote here. Update on Tetragon's Series C shareholder suit. The judge ruled that since there has been no official determination regarding XRP's status, Tetragon's claim that a securities default occurred is wrong. The SEC also responded to attorney John Deaton's case on behalf of XRP holders and confirmed what we said on day one. And by the way, let me pause there. He's talking about the response to John Deaton's writ of mandamus, which was exactly what my very last video was about. I was talking about this, published it, and then I was like, bam, Twitter news. Okay. I was like, if I had known about that, I just would have actually it would have been too much information from one video anyway. I guess it doesn't matter, but still, here we are. So I encourage you to check out that video too. There's some seriously interesting info in that last video I published, including the SEC claiming that they are not responsible for the price of XRP plummeting after they sued Ripple. It's just like insanity, nonsensical, disingenuous stuff. So check out that last video when you have a chance. But here's the rest of the comment from Stuart Alderodi, Ripple employee. The SEC also responded to attorney John Deaton's case on behalf of XRP holders and confirmed what we said on day one. Their complaint against Ripple is just allegations. The court presiding over the SEC's case is, quote, the exclusive method for testing the validity of those allegations. So what's he talking about there? You're talking about regulatory clarity through enforcement, which to me is disgusting. And then he wrote, this is Stewart again now, the Tetragon ruling coupled with the SEC's filing in attorney John Deaton's case should put to rest the FUD that the SEC unilaterally determined XRP is a security. Glad that's settled. Yeah, me too. Thank you very much for posting that. And then Brad Garlinghouse retweeted that, Ripple CEO Brad Garlinghouse, and he wrote the following. This is why regulation by enforcement wreaks such havoc. By bringing a massive enforcement case, the SEC acknowledges they didn't determine anything, but the crypto markets, under pressure, interpreted the filing as such, causing massive damage to retail holders. And now the SEC affirms that no determination has been made about XRP, and it didn't order or ask anyone to halt trading / delist. So retail holders shouldn't blame the SEC, but instead, wait for it, blame the exchanges. So who are they protecting? Exactly. That's why you've got to watch my very last video if this topic interests you. Just their response to John Deaton's writ of mandamus is off the wall bonkers. And so here's Ripple's official statement on this topic now, which Stuart Alderodi linked to. This is on the official Ripple website. Our statement on order denying Tetragon's request for preliminary injunction. Today, the court in Delaware rejected Tetragon's claim that the SEC had officially determined XRP's status. This ruling, coupled with a separate filing the SEC made today, should put to rest any confusion. The SEC has not determined that XRP is a security, as the Delaware judge stated, quote, "But XRP is no more a security after the SEC filed the enforcement action than it was before it. A determination resolves the question of whether XRP is a security. The enforcement action, by contrast, asks that question. The question is not yet resolved, so a determination has not yet been made. And when it is made, it will be made by the district court." Exactly. Therefore, Tetragon's claim that a securities default occurred has been proven wrong. Now, separately, the SEC itself acknowledged today in another case brought by XRP holders against the agency that it has not made any determination as to XRP's status. Per their words, quote, "The court hearing the SEC's case against Ripple is the exclusive method for testing the validity of the SEC's claims against Ripple." Well, how about that? And then the piece wraps up by stating, "Let's call Tetragon's lawsuit what it is, an opportunistic move to take advantage of the SEC's allegations. What has always been clear, and made so even more today, is that the SEC still has to try to prove their case in court, which we do not believe they will be able to do. As our lawyers have said publicly, the SEC is, quote, dead wrong. We look forward to bringing the SEC's case to a just and speedy resolution and remove the cloud that the SEC's misguided actions have cast over the XRP market." Bravo, Ripple. Love it. I really appreciate it too, because they have no obligation to do this, but they're publicly stating this stuff and keeping the XRP community, aware of what's going on. And certainly you could just say the general public, but let's be real. Obviously, the XRP community is most interested in this, right? So anyway, I appreciate it. This is great news. XRP is not a security today. It has not been proven to be a security. And if it ever is deemed to be a security, then it's going to happen in court, but not just because the SEC says it is the case without any sort of adjudication. But I'll go ahead and wrap up there. I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.